Dear friends, today I will discuss Section 19 of the Indian Patent Act or the Patents Act 1970. The title is Powers of Controller in Case of Potential Infringement. Fine. And as I always say, I will explain all the subsections through my key points. So, please go through the bare as well. Fine. Okay. Subsection 1 says, if, in consequence of the investigations required under this Act, it appears to the controller that an invention in respect of which an application for a patent has been made cannot be performed without substantial risk of infringement of a claim of any other patent, he may direct that a reference to that other patent shall be inserted in the applicant's complete specification by way of notice to the public unless within such time as may be prescribed. Some clauses are there. Clause A says, the applicant shows to the satisfaction of the controller that there are reasonable grounds for contesting the validity of the said claim of the other patent, or the complete specification is amended to the satisfaction of the controller. Fine. So, this lengthy subsection, it can be simply explained in a number of few sentences that I have written below in black ink. Okay. So, we will go through it first. See, reference to the other patent in the complete specification of the present patent application is not needed if the applicant shows reasonable grounds for contesting the validity of the specific claim of the other patent, or he or she amends the complete specification as per the instructions of the controller, or we can say up to the satisfactions of the controller. That means, though it is very easy to understand right now, still I will explain in some more detail. Okay. So, consider if you are applying for a patent, okay, and you are filing a patent applications. But you feel that, okay, you feel that by going through other prior arts of the other patents, you feel that your application has a risk of infringing other applications which are already granted or which are already granted patents. So, at that time, what I should do? I should give a reference to that patent in my application. As we know, while we are writing the papers, all the research candidates know that while they are writing their own papers, if they have taken some reference, if we can say that even that means he or she has taken any kind of instructions or anything else from some other papers, that he or she must give a reference of that paper in their paper. Right? Similarly, in the same way, when I will apply for a patent and I feel that I have taken any kind of ideas or anything else, or I feel that I have a risk of infringement to that particular patent, I must give a reference to that patent in my application. Fine. But this kind of reference is not needed if the applicant shows some reasonable grounds for contesting the validity of the said claim of the other patent. Okay. Or another case is that if the applicant who is applying for the present application, he amends his or her application as per the instructions of the controller. In these two cases and in a prescribed time, okay, the need of reference is, or we can say that a reference is not needed. But if it is not satisfying these two clauses, then a reference is a must. I think now it is more clear. Fine. Now I will go to subsection 2, where after a reference to another patent has been inserted in a complete specification in pursuance of a direction under subsection 1 of this section, clause A says that other patent is revoked or otherwise ceases to be in force, or clause B, the specification of that other patent is amended by the deletion of the relevant claim, or clause C says it is found in proceedings before the court or the controller that the relevant claim of that other patent is invalid or is not infringed by any working of the applicant's invention. The controller may, on the application of the applicant, delete the reference to that other patent. Okay. Now, if go to the subsection 1 of this section. If clause A and clause B are not satisfied, that means a reference is a must. So, in that case, now we will explain subsection 2. Subsection 2 says that if the reference is already inserted in the present patent application, it can be deleted in some conditions. The same thing I have written here, that take a look at the sentences in black ink. If the reference is already inserted in the present patent application as per section 19 subsection 1, the controller may delete the reference to the other patent if it, that means this application, satisfies the conditions under clauses A, B or C of section 19 subsection 2 as per the request of the applicant. Fine. The same thing. That means if the reference is already inserted and the applicant now wants to delete it, then he cannot delete. He can request the controller to delete the same if the three clauses conditions are satisfied. That means clause A, that says that other patent is revoked or otherwise ceases to be in force. Just take a look at the, I am telling you, just in all the three clauses, just take a look at the underlined words. These are the key points. Fine. So clause A says that other patent is revoked or otherwise ceases to be in force, or B, the specification of that other patent is amended by the deletion of the relevant claim, or C says it is found in proceedings before the court or the controller that the relevant claim of that other patent is invalid or is not infringing by any working of the applicant's inventions. Now, out of these three clauses, either or, if one clause is also satisfied, then also the applicant can request for the deletion of the reference point. So, this is a either or situation, either A, either B or C. A or B or C. Fine. Now, I think both the sections are much more clear. Okay. So, please go through the video. Please compliment or comment in the comment section. Please share the video among your friends and subscribe my channel and press the bell icon. Thank you very much.